May it please the court?
Sure.
My name is Rebecca Mercier Vargas. I'm here on behalf of the plaintiff. With me are the plaintiff's trial attorneys, Jeffrey Fenster and Stacey Cohen. I'd like to reserve 5 minutes for rebuttal.
Certainly the yellow light will come on when
Okay.
your rebuttal time is starting.
Perfect. This fundamentally unfair trial began with the exclusion of the real parties in interest from the courtroom, followed by 2 egregious evidentiary errors that infected this trial. The trial court allowed Tandem to feature as its causation defense an inadmissible FDA advisory issued 9 months after Mrs. Gagnon died. Compounding this error, the trial court excluded a Tandem employee who had critical testimony that Mrs. Gagnon choked and did not suffer an arrhythmia. Turning a new trial is required on all issues based on all 3 of our points, but I'm going to first turn to point 1 on our briefs. The FDA advisory here stated that two medications that Mrs. Gagnon was taking had a slight increased risk in mortality in elderly patients with dementia. And let's point out that she wasn't actually elderly. She was only 62, but she did have dementia, so she had some aspects where this warning would have been applicable to her.
Well, at your age, probably 65 doesn't seem ancient.
That's right. Jane asked me to point out that 62 is not elderly.
Yeah, I appreciate that.
Anyhow, this inadmissible advisory became the feature of their case. It was focused on, from opening statement, when Tandem told the jurors that this medication stopped Mrs. Gagnon's heart. It became a critical piece of evidence with 2 of plaintiff's expert witnesses and the defense expert witness.
You would agree, though, that they had the right to pursue that defense.
Yes, Your Honor, I would agree.
So that these experts would have been able to testify and opine as to what they believed was the cause of death, which was connected to the medication she was on.
I agree, Your Honor.
So the basis of your objection is allowing, at the end of the trial, this particular document, I guess it's called the insert, to be admitted into evidence. But it came in at the end of the trial.
That's correct. It did come in physically at the end of the trial, but it had been mentioned in opening statements. In opening statements, the juror were told, this medication stopped her heart. And I agree, Your Honor, that an expert witness could certainly say, I've looked at this EKG, I think she had an arrhythmia, and in my opinions, her medications she was taking might have contributed to her death. Now, this was a hotly contested liability trial, and the problem is that by admitting this FDA advisory, it went between 2 competing expert witnesses, both elder care physicians, and Tandem was allowed to say it's not just our expert who thinks it's the government, the federal government.
Why doesn't it come in evidence under 90.803(8), which permits these things to come in if there is an agency that is duty bound to record or issue these documents?
Right, Your Honor, it is not.
You would agree the FDA has a role in placing warnings on drugs that are out there for the consumer.
Yes, I agree with that they have a role in putting out warnings. However, it is a discretionary role. In order to be admissible under the hearsay exception, it can either be a daily activity of the office, or the second way is it could be a matter observed by a member of the government that has a mandatory duty to observe, a mandatory duty to report, and a mandatory duty to make the record. None of those criteria are present here because, first of all, this is not based on the personal knowledge of the FDA. If you read the advisory, it's clear that it reviewed 17 studies and it found, conducted by outsiders, and it found that 15 of those studies showed a small increase in the risk of death.
So isn't that just an observation of the government? I mean, it's an observation of those 15 reports.
Yes, it is an observation, but it's critical to note that in Florida, there's a difference in the hearsay exception between the Florida and the analogous federal rule. In the federal rule, you can admit investigatory reports where the government is relying on outside sources. And I point you to the Supreme Court's decision in Lee, which stated that in Florida, you cannot introduce as evidence an investigative report. If the government is relying on information provided by outsiders, which is the case here, then it's considered an investigative report. Essentially, the government is conducting an investigation, and it is considered inadmissible hearsay. And then there's a reason that the Florida did not adopt that provision of the evidence code. So I would agree with you. If we're in federal court, we have a different result in this case. That's
Let me
why.
ask you a question in reference, because it's not clear to me from the record or either the briefs in this case. Once the FDA warning came in terms of, I know it came in actually in evidence at the end, but it clearly got discussed in detail during the course of the testimony in this case, both in cross-examination of plaintiff's experts and also in direct examination by the defense experts. It seems to me, as I understand it, one instance occurred in which the plaintiff was prohibited from having its doctor, having now the information come out about the FDA, be able to explain or to explain away the impact of the FDA warning in order essentially saying, yeah, I'm aware of it, but listen, it was not a large study. It doesn't really mean anything, and was prohibited from doing that based on some concept of bolstering the testimony by indirect examination. Am I misunderstanding that?
No, that is correct, Your Honor.
Who was the doctor that was put on for the plaintiff that was prohibited under that guise of bolstering?
That was the testimony of our expert neurologist, Dr. Kishner. Basically, the way it laid out was in opening statements, the jury was told these medications stopped the heart of Mrs. Gagnon. So before Dr. Vinger, who was plaintiff's expert gerontologist, testified, plaintiff said, we are forced by the court's rulings to place evidence in the record about her medications. And they did not place evidence in about the warning. It was really just about the fact that she was on some medications, and no, he did not think the medications contributed to her death. Now, when we tried to ask our expert neurologist, Dr. Krishner, about some of the studies underlying the FDA advisory, an attempt to minimize the impact, we were not allowed to do that. The trial court sustained the defense objection and said we were trying to bolster the testimony of our own expert by introducing testimony regarding the underlying studies and how they really didn't show that there was an increased risk of death in this case. And I think that just highlights the prejudice and unfairness. You can also, to look at the prejudice, see that the jurors asked multiple questions. They asked this same witness that we're discussing now a question of if the FDA issued a black box warning, doesn't that mean the government determined this causes cardiac difficulties? I mean, I think that shows that this jury was extremely concerned. They also asked this same witness about the fact that she was taking 2 of these medications and whether or not those 2 medications would have really, compounded or had a extra effect. So we know.
Didn't the FDA warning though set a very low percentage rate of that type of injury happening? Wasn't it 1 point?
Yes, Your Honor. That's true.
It was very low. So I mean, how does that fit in with the?
It was extremely low, Your Honor, and in fact, that just highlights even the defense expert, Dr. Myers, who was an expert elder care physician, testified that he could not state with reasonable certainty that this caused her death. He said, at one point he said he thinks that these medications were toxic to his heart, but then when asked about it later, he said, well, I really can't say it was more than a coincidence that she was taking these medications. And that really shows what prejudice we had from this testimony coming in.
How would you deal with an argument that would say essentially, okay, let's assume for the sake of argument the FDA black box warning shouldn't have come into evidence. Mm-hmm. However, there was and I think this is perhaps where Judge Nemorzian was going with this issue of whether it's harmless error. If you got into evidence, you don't disagree that all of these doctors either could have been cross-examined or examined about their personal knowledge and experience and belief about the combination of Abilify and this other medication being given to elderly patients with dementia, and that would have come in, and they would have had the same argument.
Right.
How would you
Well, I would
dissuade us that that's not then
I would
harmless
refer
error.
you to Judge Stevenson's opinion in the liberatory case. I think when this court is examining this type of an error, when scientific evidence comes in as substantive evidence to help prove one party's case, reversible error occurs. It is an error of misconstruing the evidence code, and this court routinely reverses. And it's especially true where it's a battle of experts. It is a very different thing when you have two expert doctors, both elder care physicians. One says, I've read the EKG and they don't show an arrhythmia. One says, I've read the EKG and it does show an arrhythmia. But then you introduce as substantive evidence a study from the FDA which puts the seal of government authority and the weight and credibility that the FDA has on the defense side and takes that away from the plaintiff's side. And that is the inherent harm and prejudice in this case. And as magnified, we know, because the jury asked multiple questions. They asked questions of Dr. Vinger. They asked questions of Dr. Krishner, both the plaintiff's experts. And this is something that was told to the jury in closing argument. It was heavily relied on. The defendant was using it as substantive evidence of the death. He wasn't just using it as impeachment. He wasn't just using it as just something that was a fleeting reference in the case. He told the jury, the drug effect, it's in evidence. Please, you haven't seen it yet, but go read it. And then he told them, he used this FDA advisory in really an improper way. He said, this medication was so terrible, it shouldn't have been given at all. Now, there was no claim of malpractice, and in fact, one of her primary physicians was the Tandem's medical director. So, I mean, if it really shouldn't have been given, it's Tandem's fault anyway. But they really misused this evidence, and it was so prejudicial because it wasn't even in effect when she died. None of her doctors knew about this, and the defense couldn't even say beyond a reasonable possibility that it contributed to her death. Yet, it was emphasized from opening statement to closing argument, and the jury was asked to go back in the jury room and read it.
So how did
Counsel, in terms of the cross-examination, it seems to me that one of your points is simply that the trial court or the expert being cross-examined didn't recognize or was not asked to recognize this FDA warning as some sort of an authoritative treatise. If this were retried, almost certainly either the court or the expert would have to recognize this as authoritative, wouldn't you?
Well, Your Honor, even assuming that you're correct, and on remand they established a proper predicate, which they failed to do in this case, that still doesn't mean that this inadmissible study comes in as substantive evidence to prove their case and to lend weight and the credibility of the federal government to Tandem's case. If you don't mind, I'd like to turn briefly to point 2. That's also a very significant point. I see I'm running short on time. We had a Tandem kitchen worker who was an employee of Tandem, and he had very important testimony that Mrs. Gagnon had choked. He would have testified both that a CNA ran into the kitchen and yelled that a patient was choking. He would have also told us that the Tandem's kitchen manager called a meeting, said that Mrs. Gagnon had choked, and that the kitchen staff had to be more careful passing out the trays. This was critical information. It directly refuted Tandem's story at trial that no one had seen her choke. The jury was told. The very last thing they were told in closing argument was, there is not a single shred of evidence in this case, whether it be from Dr. Behrens or anybody else who was on that scene, that there was anything remotely close to an aspiration in this case. That's the last thing the jury heard. And if we had had this employee to testify, there would have been a different result in this case.
And what was the logic of the
logic,
objection?
The judge ruled that under the First District's decision in Keys, the kitchen employee did not have personal knowledge, and that the CNA, he couldn't say one way or another what was the basis of the CNA's observation that a patient had choked. He couldn't say what was the basis of the kitchen manager that the patient had choked. But that's contrary. I'm sorry.
Why wasn't it admissible and just an excited utterance, the first one?
Well, we did move for it to be an excited utterance also, Your Honor. That was a argument that we made in the trial court. But the kitchen manager's statement wasn't necessarily an excited utterance, but certainly the CNA's was, Your Honor. With that, I'd like to reserve my last 30 seconds for rebuttal.
May it please the Court, Counsel. My name is Carrie Aschheim, and I represent the defendant in this matter, the appellee. With me today is Sarah Finnegan, who was one of the trial attorneys. As a threshold matter, gentlemen, I would like to address, since there seems to be some disagreement between the parties as to the proper standard of review in this case. Our position is that all of the issues that the appellant has brought forward are issues of admissibility, purely evidentiary issues, which should be decided on an abuse of discretion basis.
Well, we all know that the abuse of discretion is the standard, but if a trial court isn't free to abuse it, to have discretion, to exercise the discretion in conflict with a rule of evidence. In other words, if this is hearsay, if it was clear hearsay, the fact that the trial court decided to let something in evidence on the basis that he or she believed it wasn't hearsay, we wouldn't give them that discretion and say, okay, well, it's just an abuse of discretion.
Agreed, Your Honor.
So let me ask you this question. Let's assume, for the sake of, just for the purpose of my question, that the FDA black box warning was admissible, and we could debate that a little further. How can it be justified that, in light of it coming into evidence, that the plaintiff's lawyer was not permitted to have its neurologist explain away the fact that this was not a very worthwhile study to consider?
Your Honor,
how could that possibly be based on the theory of bolstering?
Well, Your Honor, at that time in the trial, I do not believe that the advisory had yet been admitted into evidence.
But it had been spoken about.
It had been spoken
Okay,
about.
so that doesn't impress me. Explain to me how a judge could conclude that he was going to prohibit it from coming in evidence, this evidence of saying that you're able to ask the doctor about it, and it should be, and he has to acknowledge that it exists. But on the other hand, he's prohibited from being able to explain away, or at least his testimony being permitted to say, although I know that exists, it's a very shoddy study, or it was a very small study, it really isn't worthy of consideration because it's such a small study, on the basis that it was bolstering. How could that possibly be? Because
Section 90.706 provides that only on cross-examination can the basis of an opinion be brought out.
Yes, if you're going to use a treatise in order to support your proposition about something, clearly that's what the says. But it doesn't say that having been confronted with a study or being confronted with a document, that the person cannot then be asked questions about the fact of whether he or she disagrees with the validity of that particular study or evidence. It doesn't make any sense to me.
Well, and if respectfully, if you review the totality of the expert's testimony, their particular opinions with respect to the validity of the advisory, the gravity of the advisory, all of that was discussed. The particulars of the study were not discussed on direct examination, and I think appropriately so, given the confines of 90.706.
All right.
Which leads me to another point that I would like to make as to the appellant's concerns with Tandem's experts using the FDA advisory to bolster the testimony of Dr. Meyerson. The objection was made, the appropriate objection was made when it appeared that the testimony was going too far, was stepping over the line, and the judge did what was appropriate and issued a curative instruction to the jury and did not allow the bolstering to go further any farther. The FDA advisory does satisfy the criteria of the public records exception to the hearsay exclusion, section 90.8038. And the appellant has tried to, in their reply brief, suggest that the FDA's duty to, or responsibility to issue warnings is discretionary. But what the appellant forgets is that there are many provisions of the Food, Drug, and Cosmetic Act which underscore the fact that regulation of the prescription drug market is a principal, if not the principal function of the FDA. And this necessarily includes review of clinical research to ensure safety of the public. Pursuant to, for example, 21 U.S.C. section 393b1, The FDA is statutorily required to continually monitor the safety of regulated drugs. This section says the FDA shall promote the public health by promptly and efficiently reviewing clinical research and taking appropriate action on the marketing of regulated products in a timely manner. Indisputably, this is a mandatory function of the FDA, which falls squarely within the public records exception to the hearsay rule in the Florida rule.
Well, Counsel, isn't the public records exception and the business records exception basically designed to show activities that are basically non-controversial? Either something happened or it didn't. Either a person has a driver's license or they don't. And this is a matter, though, of high controversy and discretion. So how does this really fit squarely within the public records or business records exception?
Because the FDA is an arm of the United States government, which is charged with ensuring the safety of consumers. Its very function is to compile, collect data from various clinical studies, extrapolate conclusions, and issue advisories based on those conclusions. That is the primary function of the FDA.
So coming back to my question again, if in fact it was admissible in evidence and it was controversial and it was discretionary, how in the world how can it be justified that a trial court could preclude the plaintiff's expert from trying to dispel the impact or import of that study or that warning on the theory that it was bolstering, whenever he was going to have an opportunity to say, okay, let's say it's come in, but we are simply, I'm going to explain to you why you cannot give the kind of, put the kind of impact or import on this because it was very shoddily done, very inadequate studies, and therefore you, jury, should not give it the weight that the defense is trying to place on it. How can that be justified?
I understand your question, Your Honor, and it's a very good one. At that time in the trial, the trial judge had not made a determination as to whether and under what theory the FDA advisory was going to be admitted, if or why. Okay, there were very brief references to the FDA advisory in opening statements, at which time there was disagreement between counsel and argument before the bench as to whether the FDA advisory would come in at all. At that time, the trial judge reserved ruling on judicial notice, amongst other things, and indicated that he would wait and see whether the proper predicate was laid. And evidently, the proper predicate wasn't laid during direct examination of the plaintiff's experts. That is why, in my humble opinion, that is why the court did not allow what it could perceive to be bolstering to occur during direct examination of the plaintiff's experts. I'll turn briefly to the employee testimony issue. The cases cited by the appellant in their brief are in a posit because none of them deal with hearsay within hearsay. In the instant case, the plaintiff wanted to introduce testimony of an individual named Sam Sundar, who was a kitchen worker, that he overheard a statement of an unidentified individual who may or may not have been an employee of the nursing home, who may or may not have been an eyewitness, who may or may not have obtained information third, fourth, or fifth hand. Sam Sundar also would have testified that Max, the kitchen manager, who was admittedly not present in the dining room during the incident in question, told the kitchen staff approximately 1 week later that Ms. Gagnon had choked. And notably, Sam Sundar could not say whether Max was present at all in the facility on the day of the incident or give any information as to where Max got his information. And I think that the trial court properly stated, if there's someone out there named Max who can testify as to where he got his information, let's get him.
Well, why isn't the first one, the CNA running into the kitchen and saying what she allegedly said, why is that not an excited utterance and admissible under that basis? It happens all the time where someone tell someone else in an excited and disturbed state about something, and it routinely comes in evidence based on reliability, based on the concept of its excited utterance, and therefore the person didn't have time to sort of figure it out and make up a story, just comes rushing into the kitchen and says, this lady out here is choking to death. Why is that not an excited utterance and admissible on that basis?
Because it actually lacked significant indicia of reliability, because we could not identify who it was. We could not identify whether she saw it herself or whether somebody had said it to her. There was no way to know the basis, the foundation of the information that was excitedly uttered.
And as far as the kitchen manager, that the meeting afterwards, we have an executive that works for the defendant in this case, who apparently has done some investigation, and he then makes this announcement to everybody, she's choked on it, everybody be careful, don't let, be cautious in the future about people. That's not an admission against interest by an employee of the defendant?
And again, this is hearsay within hearsay, because there's no way to identify how Max, the kitchen manager, got his information.
But that's a question of whether there's a weight to be given to it as opposed to admissibility of it, isn't it? I mean, you have the argument to say, well, he said that, he heard that, but, we don't know what all the facts are. But they get to say, well, yeah, but here is an employee who, after the fact, looked into this matter and now is cautioning everybody, be careful again about this issue because this is what happened. Why isn't that an admission against interest?
Again, because it lacks reliability. And certainly the trial judge, certainly reasonable minds could differ about that. And the trial judge made a determination based on 90.105 that the indicia of reliability simply weren't there. In fact, the trial judge cited to the Keys versus Tallahassee Memorial Regional Medical Center case at 579 Southern 2nd 201 and indicated that particularly when we're dealing with statements that are hearsay within hearsay, when they lack significant indicia of reliability, the court is well within its discretion to exclude those statements.
Well, counsel, isn't there some conflict, at least with the third DCA in the Metro-Dade case, in which they held that when you are having an admission by a party opponent, it need not be based on personal knowledge. So Keys isn't without some conflict out there.
Well, I do believe that the Metro-Dade County v. Yerby case, which Your Honor is referring to, can be distinguished. In that case, the appellee was driving her car when she was struck by a car driven by an uninsured motorist, and she filed a negligence action against the county because a stop sign was down. And to establish prior notice of the dangerous condition, the plaintiff offered accident report authored by a public service aide named Pichardo, which stated that the traffic sign was knocked down several days earlier, traffic maintenance was advised. The difference here is that Pichardo himself, the declarant, was at trial and able to testify. He did testify that although he did not recall where he got the information, that at the time he prepared his report, he had done his due diligence and it was an accurate representation of his findings. So the court, under a 90.105 analysis, would there certainly find that reliability had been satisfied.
Can I ask you, going back to the FDA thing, if we were to conclude that it was error to let the FDA warning in evidence, either by way of direct examination, cross-examination, and ultimately in the final analysis, and then combined with the final argument, what would be your best argument that that's harmless error?
I believe the only issue is that the admission of the FDA advisory itself was error. Discussion of the FDA advisory, when appropriate, on cross-examination.
Let's just assume, for the sake of my argument, that the whole thing was inadmissible, that it should never have come in to be discussed and no foundation was properly laid. Assuming that would be our ruling. I'm not saying that is, but assuming that was. What's your best argument that is even so harmless error?
That both of the plaintiff's experts said that independent of the FDA advisory, they were aware of the known side effects of arrhythmia and sudden death in these types of medications. And that's my time, gentlemen.
Your Honors, just briefly, I'd like to first address the court's questions. Judge Chizuri is absolutely right that the prejudice from this was admission of the FDA advisory was overwhelming because, first of all, there was no person with personal knowledge of the study, so we couldn't cross-examine anyone about the underlying studies. We couldn't ask our own expert about the underlying studies because the trial court sustained objections to improper bolstering. This left the plaintiff with no way to rebut Tandem's repeated and persistent argument that these medications stop Mrs. Gagnon's heart. So this trial it just changed course from a question of whether Mrs. Gagnon choked in coleslaw in the dining room, whether she'd been properly supervised, whether they knew that she had swallowing problems yet did not sit with her at her table, to this question of whether this mysterious arrhythmia, which the FDA, Tandem said, was likely to happen, caused her death. Plaintiff had no way to rebut that evidence, and if you examine your bolstering cases, you'll see in Liberatore, in Green, and in the Donchik's opinion from the 3rd District, the courts don't engage in a harmless error analysis. They find it's reversible error, and the reason is because there's no way to combat that extra credibility that's given to the other side's expert witness. With that, I'd ask this court to reverse for a new trial. All 3 issues in this case warrant reversal. Thank you.
Thank you very much.